Okay,
This meeting is being recorded.
there it is.
How
Aaron,
exciting.
to you. And I'm going to ask the rest of you to mute, please.
Thanks, Shirley. So I think I know almost everyone on the call, so I won't introduce myself again. But as Shirley said, a significant part of my practice is my pro bono practice. And I had the privilege of representing the Jackson Women Health Organization. And I'm going to share my screen occasionally, but not always, because I don't like leaving it up. So, but I think this is a nice visual. So I had the privilege of representing this clinic, the Jackson Women's Health Organization, along with my co-counsel, the Center for Reproductive Rights, and Rob McDuff, who I always like to give Rob a plug because he's a legendary civil rights lawyer in the South. He's based out of Jackson, Mississippi, and New Orleans. And I found over the years, whenever you find a major civil rights victory in the South at the Supreme Court, Rob's name is inevitably on the case. And so I feel like he's really a giant of the civil rights movement over the last 40 years and doesn't get as much recognition as he should. So he's really, truly a legend. But I represented this lovely organization, the Pink House, for over 10 years. It was the last abortion clinic in Mississippi. It is now no longer, as you know. When it was open, it served several thousand women every year. A significant percentage of which were lower income women, women from the African American community, and women from rural Mississippi. As you may know, depending on how much you know about rural healthcare, but there's a real crisis in rural healthcare in this country, and the Delta in Mississippi is a wasteland, especially when it comes to reproductive rights and reproductive care. There's almost no OB-GYNs in any of those regions. So the fact that my clinic was able to service women not only for abortions, but also for general reproductive health was a critical service it provided to the community, and now it is gone. So I don't think you can understate, that loss because the nearest reproductive health services in Mississippi are now hundreds of miles away. And it's particularly tragic because, as many of you may know, the U.S. has one of the highest, if not the highest, rates of maternal mortality in the sort of what we'll call the Western world. And Mississippi is always either the worst or top three of worst maternal mortality and infant mortality. And the governor won't even do basic things in Mississippi like expand Medicaid to help women access reproductive health services and OB-GYN services. So the loss of my client there is just a huge hole in that community, and especially amongst the most marginalized in Mississippi. So I wanted to start there because I do like to start with my client, because it really was one of my favorite clients of my 20-year career. But I do want to, as the blurb for this talk said, I want to talk about where we are practically and what the real impact of the Dobbs decision. And look, the disadvantage of not being in person is I feel like I can connect a little better and maybe be a little more, inspirational in person. I think this format lends itself to maybe a little more exploration of some of the intellectual issues that are at play here. And I am going to focus on that today. And some of the issues I'll talk through may require further discussion. So I'm happy to have, like a Havruta or something later with people if they want to kind of dig in a little deeper, because I think there's some really important issues that have been lurking beneath the surface of this, of the debate over reproductive rights for years. And I think the Dobbs decision has really brought them to the fore. So I want to kind of point to those two issues that I want to talk about today. I'm not only going to talk about these, but I want to kind of weave them through my talk, because I think they're two critical issues that facing us. I say us as like the reproductive rights and the reproductive access movement in the United States. And the first is, does and how much does our culture and our country value women's autonomy over their own bodies and their own reproductive choices? I think I mentioned this last time, and I keep saying it because it's really animated a lot of my work, is that, my wife, as I said, she pointed out to me at some point that the kind of struggles and the disputes over reproductive rights stem, at least in part, with an intense discomfort that I'll say people, but maybe men, maybe more than men, feel over the fact that women ultimately control the reproductive process. And I think maybe put a slightly different way, if the issue for the anti-choice movement is protecting the rights of the unborn, as they call it, why is the state better place to do that than women themselves? And I think this is an issue that is often left unexplored in definitely the legal jurisprudence, but the sort of appropriate locus or the place of the decision-making over reproductive rights. Should it be with the woman herself, or should it be with her family, with her partner, with the state? And I think what recent cases are saying about that is deeply troubling to me. And I want to pause here. It's been something that I think our movement has been dealing with, but I'm going to use the term woman throughout this presentation just because that's what I'm used to using. But I mean, obviously there are people who don't identify as women who are able to get pregnant and are part of this movement and need access to these rights as well. So if any of that really bothers anyone, let me know. I'm happy to switch my language, but it's just it's how I've been thinking about it, and I don't mean to be uninclusive. I also want to talk about, and I think significantly for this community, what does the Dobbs decision say about the future of religious pluralism in our country? If you know anything about the history of the abortion movement in the US, you'll know that that issue was a key vehicle for the rise of the Christian right and the extreme Christian right in the Republican Party in particular. And so if Dobbs represents a victory for that community, and it's very explicitly a big part of that community has been very triumphalist around this, does it also signal a triumph of conservative Christian perspectives that threatens religious pluralism more broadly, like beyond the realm of abortion? And, to kind of preview the answer to that is I think it does. And I'm going to sort of give you some very concrete examples of why I'm kind of deeply troubled by some of the rhetoric and language and that are used not only by the litigants in these cases, but by the courts, by elected officials themselves, that I think should deeply concern religious minority communities in the United States, including our own. So I'm going to turn to Dobbs now. But before I do, I want to take a little quick detour into how we got here, because I think it highlights really how radical a decision Dobbs was. And I think we people who are concerned about this issue often focus on the incredibly important fact that it overturned Roe versus Wade. But I think it did some other things that are equally disturbing. I mean, not equally disturbing, because obviously the loss of the right of access to abortion is the most important issue. But there's some other things the court did that I think are troubling long-term as well. So I want to start with Planned Parenthood versus Casey, which was a 1992 decision. It was the first. There was other cases after Roe. Roe versus Wade was 1973, but Casey in 92 was really the first big abortion decision after that. And at the time, there had been significant changes in the Supreme Court, and I think everybody expected the Supreme Court to overturn Roe versus Wade in 1992. Some of you may have lived through that and remember the discussion around it, but we did some clips from the newspapers, and the newspapers a couple days after Casey were all kind of shocked that it upheld Roe. And so, from my perspective, when I went back and looked at that case, I think what was really significant is whereas the Roe case really grounded the right to abortion in privacy, right? The idea that there was a zone of privacy that the state couldn't interfere with. Casey was much more explicit in grounding it in the liberty rights that are existing in our Constitution and around women's autonomy and rights to control their own decisions. And so from that perspective, it's a much stronger decision if you believe that, autonomy is really the core of the right to control the reproductive process, women's autonomy in particular. The problem with Casey, and the problem that kind of culminated in Dobbs, is that it really kind of sowed the seeds of its own demise in the language of that decision, because ultimately Casey was a compromise. It was a compromise, to be blunt, between really involving Justice Sandra Day O'Connor, who was softly pro-life and had some deep concerns about abortion. And so you can see her voice in that case, I believe, when there's a lot of discussion about the interest of the state in protecting the rights of the unborn, the interest of the state in reflecting other interests in the community, including spousal rights, It has this language around, protecting women from the regret they might feel over abortion. A real kind of, patronizing patriarchal view, even though it was espoused by Sandra Day O'Connor, I think. And I think the problem with it is because that was such a deeply held belief by some members of the court, they created this compromise, which was that the state could override or impinge on women's autonomy for the first 20 weeks of abortion of a pregnancy, provided it didn't the language they used was like unduly burdened, but basically is that it didn't make it too difficult for women to access abortion. And the problem with that is that was a real erosion of the idea that women had this sort of zone of autonomy. It was called privacy in Roe, but it really was a zone of autonomy to make their own decisions free of the interference of other members of the community and the state. And what that led to is the almost immediately after Roe, after Casey was decided, the anti-choice movement started passing law after law after law that was chipping away and chipping away and chipping away at the right to abortion. And in sort of a self-fulfilling prophecy led to a real mess that we had prior to Dobbs, where you had this patchwork of like crazy regulations around abortion, and it was getting harder and harder for the courts to figure out how to apply Casey in a way that sort of was trying to balance between women's autonomy and the state interests, prior to 20 weeks of pregnancy. But I think the two really important things about Casey, when I went back and reread the case after Dobbs was decided, is it said two things. It said, one is that women had an autonomy, right to their autonomy under the Constitution, under the liberty right. And that liberty right was one that had to evolve as the country itself grew and changed and the core values changed. So it was a dynamic right, one that would change over time. And I think importantly, as the women's rights movements grew in the 20th century, you really saw that liberty right expand. Secondly, it said that the court and the state had no right to impose a particular moral viewpoint, the decision of when a life was worth protecting against the difficulties that a pregnancy might cause, that was ultimately a decision for the woman to make up to a certain point. And that there was no ability to impose a moral viewpoint. And I flagged those two things because you're going to hear in a second how Dobbs tossed those out, both of those concepts out, in a way that I think has gone unremarked to some extent in some of the analysis of that decision. So going back to a little bit of the history, all these regulations are being passed. And so the pro-choice movement started fighting back and challenging these laws. And I was part of many of those challenges, and we got some of them struck down. And we really hit a high watermark in the Whole Women's Health v. Hellerstedt case in 2016, which I mentioned in my last talk, where the court there said, finally, because all these laws were being passed and they were fake laws. They were like, oh, it's there to protect women's health, but there was no science behind it and there was nothing they were doing to protect women's health. And so the court there said, look, you're going to keep passing these laws unless you have good evidence that there is some legitimate medical health and safety reason to pass these laws, we're going to strike them down. So we thought, fantastic, we're finally have a better standard. We can finally start knocking out all these laws and getting back to what access to abortion looked like pre-1992, because you can see on a line graph that like pre-1992 and post-1992, the access to abortion, especially in the South, drops off precipitously. And it's all because of these regulations. They were called trap laws or targeted regulations against abortion providers. So that's really why we brought Dobbs, because we thought, great, we're going to go after these laws. And I don't think I had time to say this, but I really, if you don't understand how Kafkaesque some of these laws were, so my client, right, one of the things they did is they imposed on all these clinics, you had to have the same facilities as a surgical procedure center. And so any of you know anything about abortion, right? About half of them are performed by pills. You come, you pick up a pill, you go home, right? There's no procedure at all in the clinic. And you only have to do that because the government made you show up at the clinic to pick up the pill. There's no reason to do that, but they made you do that. And secondly, the abortion procedure itself that were performed in these clinics is you don't even go under sedation, really. It's a very quick procedure, very safe, one of the safest medical procedures performed on a routine basis in the world, really, right? But one of the laws that we used to talk about all the time is that the state of Mississippi required my clinic to have a generator that was capable of supporting life support equipment, right? The reality is, like, no woman who came into that clinic ever went under sedation, ever got within 1,000 yards of life support. And if anything had have happened that would have required more intensive intervention, they immediately go to the hospital. And yet, if that clinic was out of gas, there was an anti-choice person there to sort of write a letter to the health department saying, close the clinic down. If that generator broke down for 4 hours, it would tie the clinic up for 2 months in paperwork and cost and replacing it. And it was like regulation after regulation after regulation like this. And so much so that my clients spent like 20% of their time, we looked at the time records, basically complying with these ridiculous laws that had nothing to do with the health and safety of women. So, that Kafkaesque situation is better than what we have now, obviously, but it still was incredibly onerous and taking away from patient care. So we were about to file this lawsuit, and the state of Mississippi passes a 15-week ban saying no abortions after 15 weeks after the last menstrual cycle. So we challenged it. We had some initial success. It goes up to the Supreme Court. And I want to pause here for a second, because the politics around this, and I know I mentioned it last time, but I've been reflecting on it recently, right? When they went up to the Supreme Court initially, the question before the court was, can a 15-week ban be constitutional? That was the only question up. Justice Ginsburg died. The court says, okay, we're going to hear the case after Justice Ginsburg dies. And the first brief that the state files after that, the question now is not, is this 15-week ban constitution, but overturn Roe versus Wade. And I'm not a Supreme Court practitioner. That's not my gig. But I am told by multiple Supreme Court practitioners that this is almost unheard of, that you essentially change the question from when you ask the court to hear the case to when you file your briefs is almost never heard. As a matter of fact, when it does happen, often the Supreme Court do what's called, I think it's kind of quaint, they'll call it dig the case, which is basically it's decision improvidently granted. It's some archaic terminology, but basically say, look, parties, we granted this case on one question. You can't just go ahead and change the question. We're going to send you back and you go sort it out at the lower courts. The fact that they didn't hear, and the fact that it was clearly and transparently because Justice Ginsburg died, and that they now had a 6-3 majority, was so egregiously political that I really think, in terms of this long-term conversation about the legitimacy of the Supreme Court, I think they did serious damage to their legitimacy, not just amongst sort of the progressive community. I think there was a lot of middle of the road Supreme Court practitioners who were very concerned about this, about how the court handled that. Anyway, the decision comes down in June 2022. You know the results. But I want to kind of come back to my issues of autonomy and religious pluralism, because you know the ultimate result. But I want to talk about those two issues in the context of Dobbs, because I didn't do that last time. So in terms of the issue of women's autonomy, and not that this is a completely safe space, but it's all treated as somewhat of a safe space. Justice Alito's treatment of women is appalling. I've seen and heard how he treats women advocates versus male advocates, and it's really, really troubling. He cuts them off. He doesn't let them finish. And people have actually done studies about Justice Alito's treatment of women at the Supreme Court. And it's actually quite striking about how different his interventions and the length of his interventions and the interruptions. And I say that not because I don't know one way or the other whether he is a misogynist or not, but I found his decision, because he was the one who wrote the majority, deeply troubling and almost chilling in the lack of a woman's perspective when he's talking about this fundamental right. And I think that maybe the best example of that is, one of our arguments was that, look, as a liberty right, the court has already found similar, liberty rights that are kind of, have evolved, with our society, like the right to interracial marriage under Loving v. Virginia, like, the contraception cases from the 1960s, where some of you, I didn't know this, but it turns out that it was illegal to get contraception in many states prior to some of these decisions. And obviously more recently, the same-sex marriage cases, right? So we said, look, the court has evolved in these areas. There's no reason why you couldn't do the same thing in abortion. And Justice Alito said, no, hang on a second. Abortion is different than any other right that you're talking about, because somebody dies, right? The fetus dies, right? So you can't analogize it to those decisions. And he goes on at some length about that, but nowhere does he talk about why this right might be different from the woman's perspective. You know what I mean? That, like, this isn't the same thing as getting contraception. It's not even, and as significant it is to enter a loving partnership with someone, the reality of pregnancy is something that's radically different than any of these other rights. And that discussion is completely and totally absent when he's talking about how this right is different than any other right. No recognition that it might be different from the woman's perspective as well. And I think, and I think another way he criticizes it when we were trying to make this analogy, he says, look, hold on, you crazy, reproductive rights advocates. If we let you just sort of change the definition of liberty, you're going to start asking for all kinds of rights, in addition to abortion. You're going to start telling me that illicit drug use is a personal liberty, or God forbid, prostitution, right? And again, I grew up in an era of like postmodern literary theory where I believe the text can say something about the people who are writing it. And I think these two choices of examples are incredibly telling. That, like, remember I said about like, what does these decisions say about like society's view about women's capacity to make these decisions? Well, I think the fact that Justice Alito analogized it to illicit drug use and prostitution maybe tells you something what he thinks about the women who are making decisions to have abortion. Again, I can't prove that, but I do think some ways the examples he gave are incredibly telling. The second thing I want to point out in terms of autonomy, and I mentioned this before, so I won't belabor it, but it goes back to, remember I said in Planned Parenthood versus Casey, they said, look, the liberty right can evolve over time. Well, Justice Alito shut that down. He says, no. Any, if it's not written in the Constitution and you're trying to claim it's a liberty right, it has to be deeply rooted in the traditions and history of our country. And the problem then is when he tries to figure out what that is, he goes back and looks at all these laws dating back to the medieval times. I really wanted to play, if you guys haven't seen, there's a Saturday Night Live clip where they're showing like, these two medieval monks arguing with this other person about how they're going to like regulate abortion. And it's absolutely hilarious and like super spot on for like, I kind of imagine what the justices were talking about in chambers. But like the thing that, again, he doesn't remark on is like this catalog of laws that he uses to prove that abortion was never protected right. It won't come as a shock to you that most of those laws were passed by legislatures and political actors that the women were completely disenfranchised. Right? They had not only couldn't they vote, they didn't even have any political power really during many of these times. So the idea of trying to figure out whether women had an autonomy right or right to control the reproductive process by looking what a bunch of white men did in like the 1860s is, to me, just such a fundamental misunderstanding of history and how the women's rights movement has evolved. And I think, again, like in this like catalog of like lack of self-awareness by Justice Alito, he's like, look, you crazy reproductive rights advocates, you can't even find me anything that talks about abortion as a constitutional right until like the decade before Roe versus Wade. And I felt like screaming at him, right? Well, that's because the women's rights movements really started getting political power like post-war, right? So of course it wasn't talked about before that, because women weren't allowed to talk about these things except in some narrow circumstances. But again, just sort of seems to go right by him that this approach that he's taking, and which I think is breathtakingly conservative, and I mean this by a small c conservative approach. And I flagged this before, but I really can't emphasize it enough. It is a huge threat to a whole series of rights that have been found in the Constitution. And I believe that the conservative legal movement is going to use this to continually go after LGBTQ rights, same-sex rights. You may or may not know this, but I think it was Idaho that recently passed a law that banned providing contraception to rape victims, like Plan B kind of things, right? And that is they're targeting a contraception right. And there's many people. There's still a marginalized part, but there's a wing of that community that believes that contraception itself is killing a fetus. So they are going to come after all these rights, and Justice Alito has given them the tools to do that. The second thing I want to touch on briefly, because I don't think Dobbs speaks as clearly to religious pluralism as it does to this whole idea of women's autonomy, but the Justice Alito he spends basically no time talking about women's autonomy or women's perspective, and a lot of time talking about what he calls field rights, or the rights of the unborn, of unborn life is what he calls it. And he actually chastises the liberal justices, Judge Sotomayor and Justice Kagan, for not spending enough time talking about the right to the fetus's rights. And he doesn't really kind of interrogate sort of where this state interest in protecting fetal life comes from. He doesn't sort of look at whether that's an appropriate state interest or not, and I think he should have. But I think most importantly, what I wanted to flag is that his whole position is, look, let's just send this back to the states. You know, the federal government has nothing to do with this issue. We'll just let the states decide. Well, anyone who knows the history of this country knows that when you delegate stuff to the states, that's where minorities typically like do the worst. I think like ultimately, and I'll come back to, I think that move was disingenuous for another reason, but I think ultimately what he's done by saying, let's delegate this back to the states, is to basically put religious minority communities who don't necessarily agree with a particular Christian view of abortion are going to increasingly find themselves marginalized in some of those states. And I'm not just making that up. I know you might feel this intuitively, but I wanted to flag what the governor of Mississippi said. So when he passed one of these bans, he said on Twitter very proudly, we will, and this is the governor of Mississippi, we will all answer to the good Lord one day. And I say in this instance, I fought for the lives of innocent babies, even under the threat of legal action. So that's what he tweeted out one day after one of the abortion bans were passed. And there was many other examples of legislators in Mississippi using that kind of very extremely religious language when they were talking about these abortion laws that were being passed. And I don't mean religious, I should say, be more specific, very Christian language when these laws are being passed. And I was always a big proponent of calling this out, and I got it into our complaints quite often, but there was a real reticence, and I'll come back to that in the progressive community to sort of make a bigger deal of those arguments. But the second thing I want to show, and this is a little gratuitous, but I really want to show this because it was probably one of the most striking moments of my legal career. So after we lost in the Supreme Court, there was actually an existing right to abortion under the Mississippi Constitution. And so we brought, it could be termed nothing other than a quixotic lawsuit in the Mississippi Supreme Court, trying to convince this, you know, the right was founded in 1994 when there's a lot of Democrats on the Supreme Court in Mississippi, and now it was all Republicans. So we knew this was doomed to fail, but we thought maybe we can keep the clinic open for another month or two. And so we have this court hearing, and I want to play for you the video. Some of you may have seen it already. Okay, I'm only going to play a bit of this, but okay. So this is to set the scene. This is the courtroom at the trial court level of Mississippi. This is Judge Halford. This is Rob McDuff. You can only see the back of his head, but there's the man, the legend himself. And this is my co-counsel at the Center of Reproductive Rights, Hillary Schneller, a Jewish woman who told me after this thing that she literally did not know what to do for one of the first times in her legal career. So I'll play it now.
In accordance with Judge Alford's standard practice, those of you who wish, you're invited to join us for a moment of prayer and reflection brought by Reverend Calvin Cosnahan, serving as a special chaplain for today's session. All others are requested to remain silent and respectful of the court decorum during this time.
Lord, we pray for the presence of your Holy Spirit in this courtroom today. We lay before you our passions, emotions, and anxieties concerning the issues involved in this case. We seek your truth, not our own. We seek your wisdom, not our own. Bless and inspire Judge Halford in her deliberations and judgments here today. Bless and inspire all those who address this honorable court to do so with a sense of your presence and your will for them today. Enlighten our minds, strengthen our spirit, and fill our hearts with love, wisdom, and understanding.
So I hope you all could hear that. But going back to Hillary, she was like, as a Jewish woman, what am I supposed to do in that situation? Because she said, I wanted to stand up and say something right now about how inappropriate that was. But she obviously didn't want to jeopardize the rights of our client. But I played that video for you. Not, look, that happens. Rob tells me that happens all the time in the South. But because I do really believe these latest decisions have emboldened Christian conservatives in the South in particular, and they're becoming much less shy about articulating things like that in state contexts where I don't think it traditionally has had a place or at least groups like the ACLU have argued it doesn't have a place. So while I don't think Dobbs is squarely about religious issues, I think the decision was a big win for Christian conservatives, and it's going to fuel efforts to institutionalize their viewpoints across a range of issues. So let me now talk about, let me just pause there because about halfway through. So does anybody have any thoughts or questions so far?
There's one question in the chat from Richard that you might want to take a look at, and it's about the that Iowa banned the day after pill access to rape victims. I think you were talking about what was going on at the state level, and I think Richard is basically underscoring what happened in Iowa and Idaho.
Richard's just Western shaming me because I couldn't tell the difference between Iowa and Idaho. So, but I don't forget, Richard, I'm Canadian, so it's not entirely my fault.
Yeah, fair enough. It's not a province. But don't you think crossing the state border laws have the potential to end up in the Supreme Court as well? I mean, the Idaho law would seem really troubling.
Yeah, the idea that if you bring a minor across the border, you're trafficking somehow. Yeah, I mean, Justice Kavanaugh promised us that those kind of laws would be struck down by the Supreme Court, but I don't have any faith in this court. I don't have a lot of faith in Justice Kavanaugh. But yeah, I mean, those will absolutely end up in the Supreme Court. I mean, and I actually think we may have some strange bedfellows on that one, because I think there's actually a lot of companies that are concerned about some of the states' attempts to impose on interstate commerce. Jerry, I saw you had your hand up too, I think.
Yeah, I was curious, that tape you just played. I believe I heard them say in the course of it that we pray that we will be able to I'm paraphrasing, we'll resolve this case in accordance with God's law.
100%.
Which is astounding that it would get stated. I mean, we all know that may be behind what they do, but I wonder, and if that's a common practice, has there ever been a constitutional challenge that the state is formally allowing an invocation encouraging decisions based on religious law?
Yeah,
I can't believe they said it.
So I should have said, I mean, this may shock no one, but that hearing was in the morning, and we got like a 12-page written decision like at 4 o'clock that afternoon. So like God had already spoken to her, and she already knew what she was going to say before we even stood up and argued. You're right. And so I actually, like Jerry, I literally picked up the phone and called Rob. I was like outraged because I was on Zoom for that one. I wasn't traveling, and I was like, how do I file my motion? And he's like, for what remedy? He says the problem with that situation is you might at best get a declaratory judgment that she violated the First Amendment of the Constitution. But there's no remedy, there's no effect, there's no damages. You can't go back and do a redo. Like it's an incredibly toothless law. Doesn't
it call into question the final decision? It calls into question the final decision in the same way that if you found out she wasn't a judge, you would say, wait a minute, we can't enforce her decision.
Yeah.
We just heard it said that she's going to make a decision based on religion.
Well, I don't want to be glib, but the person in charge of enforcing the laws in Mississippi wished Godspeed and God's will to the Supreme Court in making the decision. So, I don't think there's any judicial or state actor left in Mississippi that an argument that, the trial court judge made a decision based upon God's law instead of the law of the United States is going to move them, because I don't think they see anything wrong with that, and that's why I'm deeply troubled by this issue of religious pluralism, because I think, as much as we're all
there's no federal constitutional issue with it.
Not there, but there is through the 14th. I mean, I don't want to get technical legal argument, but the 14th Amendment arguably incorporates some of the First Amendment rights. But the Mississippi state constitution has actually more expansive separation of church and state clauses. It's just basically ignored. And I think that's an ongoing crisis in this country, that people are now ignoring the separation of church and state issues. And I think as rightly as we all are to be concerned by the rise of anti-Semitism, I would argue this decline in religious pluralism should be equally concerning for religious minority communities.
And Aaron, I'm going to tell you to move on, because that's a whole other, but I'm happy to have you come back and do that one too.
Yeah, that's a kind of a passion of mine. I will come back to it briefly, but only briefly, I promise. All right, so let me talk about the fallout from Dobbs. I want to go back to one of my slides. So where is abortion under threat? Or maybe the question should be, where isn't it under threat? So this is a map of this is already out of date. I was going to say this is changing so quickly that when I came and spoke to you in February, I said that there was 12 states that had banned abortion completely. Well, by March 1st, there was 13. This map is current as of mid-April, but you can see down here, Florida should now be a different color because they just passed a 6-week ban. And so all the dark red here, the dark red of my screen, these are completely banned. That's 13 states. And these red states are ones that are hostile. And some of them may surprise you, like, okay, again, I'm Canadian, so apologize, Pennsylvania, Michigan, right? You're laughing at me, but spare me, but you got to give me a break. These have Democratic governors, right? But they've got incredibly anti-abortion laws on the books still. Wisconsin's in here somewhere. I don't know where Wisconsin is. You all know where Wisconsin is. Was that Wisconsin? That was Wisconsin. But Michigan's also a problem. So the bottom line is that we haven't changed our predictions that about half the states are going to have enacted total or near total abortion bans soon. I'll leave this up for a second because I think one of the most striking things is that the travel time to access abortion since Dobbs has tripled, right? In 1 year, it's tripled. And I gave you an example. So, Jackson, I don't know, it's like right about there. So they had to travel, they now have to travel 420 miles to Carbondale, Illinois, or over here to Tallahassee. Well, Tallahassee is not an option anymore. And actually, the monthly rate of abortion in Florida had gone up by about 1,200 since Dobbs because it was actually a refuge, and now that's gone. So this is essentially an abortion desert now. Any woman who gets pregnant has to travel hundreds and hundreds of miles.
Aaron, can I ask you a question? In terms
Yeah.
of the red and the maroon, the deep dark red or whatever, the hostile versus the complete ban.
Yeah.
Like what's included in a complete ban? Does that mean rape, the pill, everything? Like what's the difference between hostile and, and how much range is there in the complete?
Yeah. So of the 13 states that ban completely, only 4 have rape or incest exceptions. And of those, I think one of them has only rape. As you're hearing, like the Republicans are aware this is not a great issue for them, right? Abortion, they're losing on it. So they started to shift their rhetoric and they're talking about these health and life and rape and incest exceptions. But you got to remember, the rape exceptions, to access the rape exception, the rape victim has to make a verified police report, right? So they've got to, after their rape, some of these states, like you can only get it within 6 weeks. So before you even know you're pregnant, you've been raped, you don't even know if you're pregnant. You're supposed to go into the police, report a sexual assault, say you're pregnant, get the police report, take that police report into your doctor, who, because there's so many conflicting standards, the doctors are probably not going to accept it without 700 lawyers telling where they're going to. So these rape exceptions, these incest exceptions, if they exist, they're functionally useless for women. And even the health and life exception, and I'll come back to in a second, is not very helpful either. And I'll give you a very concrete example of that. So these total bans are total bans. Like I'll just give you another statistic, right? So the impact is that in the 13 states that have banned abortion completely prior to Dobbs, there's 7,600 women a month getting abortions. That's down to 200 a month now. Now, some of that slack has been picked up by neighboring states, but not all. Nationwide, the rate of abortion has declined by 6%, which is striking when you consider that the most populous states in the country protect abortion, like California, Illinois, New York. So there's a huge number of women right now that are simply not getting access to these services. A couple other quick things, conscious of time. Some things that, like, not that we didn't expect them, but have happened faster than we thought. So access to OB-GYNs, right? States that have banned abortion in this last round of residency applications, they've seen a drop of 10.5% in applications by OB-GYN residents, right? And what does that mean? Well, vast majority of people where they do the residency, they'll stay to practice. So now not only is this an abortion desert, but you're going to start seeing a decline in women's access to just the basic reproductive health services. You've probably heard, and I think I got the state right this time, Richard, in Idaho, there was a hospital that closed its labor and delivery clinic. Because it was a number of reasons. It wasn't just because of the abortion ban in Idaho, but the hospital specifically said because they were having trouble with recruitment because of the political climate. So, I think that you're really going to, and I've also seen, and these are really anecdotal, but it's not going to shock me if you ask me about the future, is that college applicants, there's, people who are looking to apply to medical school aren't applying to Texas. They're not applying to Oklahoma. Mississippi has great teaching hospitals in Jackson. We're not going to go there. And I actually am concerned that you're going to see a slow sorting, right, of our population into people who are comfortable with this and people who are not, which I just think is going to further the already incredibly vast divisions in our country. So I don't mean to be alarmist, but we're seeing in data like a slow sorting of people that were triggered by this decision, which was only a year old. I want to come back to, Rabbi Julie, that question about harm to women. So some of you may have seen, and I apologize if you have, but there was a story in NPR, and I just picked this one. I can pick a dozen stories every week about women's stories, right? A woman in NPR had something called a molar pregnancy, which I don't even know what that was until I read the story. Where she was bleeding profusely. And Oklahoma currently has 4 overlapping and conflicting total abortion bans. And doctors literally could not even tell you what the standards are, even if they wanted to try, because the laws literally conflict. And so this woman goes into the hospital and an ultrasound technician detects a heartbeat in the fetus and basically tells them to stop, or basically threatens to report them, is the gist I got. So the doctors stop. Her husband these are conservative, pro-life, couple. Her husband goes crazy, demands to talk to the medical ethics board at the hospital. They refuse to see him. The woman has been bleeding, and also because of this particular type of pregnancy, her rates of the pregnancy hormone, which makes you incredibly nauseous, are like 10 times what it would be in a normal pregnancy. So she's throwing up and bleeding. She's weak and delirious. She can't make any decisions herself. Her husband's being shut out from the apparatus. Finally, thank God, the doctors tell her to go wait in the parking lot, and when she starts to bleed out, they'll be able to treat her, because then they're confident, their lawyers tell them that will survive the current mismatch of laws in Oklahoma, right? Her husband says, I'm absolutely not doing that. So thank God a doctor takes pity on them, risks their license, because there's a bounty law in Oklahoma, right? So if some private citizen decides that you've aided and abetted abortion, they can sue you in court for tens of thousands of dollars and try to take away your medical license. So this doctor risks all that, tells her to go to Wichita, where there is a clinic. So they cross their fingers and pray, because they've got to drive 3 hours in the car. She's bleeding and could bleed out at any minute. The doctors have told her she may have no more than 2 weeks to live. So she goes to Wichita, and she gets the procedure and has a really great experience from the people there. But this is the kind of decisions that are having to be made by doctors and their patients. Meanwhile, you've got the leading bioethics people telling doctors, you've got to treat these women no matter what. Even if you think you're risking your license and your practice and everything, you've got to treat them. You're compelled to under your ethical standards. And the doctors are like, hell no, you come and treat them, right? So it's just an absolute and total mess, and women are being harmed. We're going to see the maternal mortality rates go up. We're going to see the infant mortality rates go up. And, I am emotional about this. I try not to get too much, but I get really frustrated when I hear people talking about pro-life things when they're literally killing people. It's an incredibly depressing situation at that level. So I also wanted to, people ask me about this, so I want to make sure I touch on it, right? When I came back to when I said how disingenuous I thought the Alito decision was, he's all over that decision, and Brett Kavanaugh talks about it, and his concurrence. He's like, look, we're going to send this issue back to the states. It should be decided the states. Let's get this decision back to the people. Well, literally within months, right, of that decision, we see they start to think about challenging the mifepristone, right? So some of you may know this, but medication abortion, about 50% of abortions in the country right now are performed using medication abortion. It's a 2-drug regimen. You take mifepristone, then you take misoprostol, right? It's a very safe, you can do it at home. It's probably, even before the Dobbs decision, it was increasingly probably the preferred mode of treatment. The plaintiffs challenged the FDA's approval of mifepristone, and they did it in a very particular way. I'm talking about the politics of the courts, right? So the case was filed in Amarillo, Texas. And why was it filed? Well, they needed a federal judge, because the federal judiciary has the power to issue what's called a nationwide injunction, right? So you can have one judge sitting in Amarillo, Texas, decide that mifepristone can be banned for everyone. Doesn't matter if you're in a state that protects abortion or not. Nobody can use it. Now, who is the judge? I know most of you probably know this, right? Judge Matthew Kaczmarek, who was a Trump appointee, who'd been incredibly willing to pass nationwide injunctions around immigration policy and other things, right? So this was clear judge shopping, and the plaintiff was called the Alliance for Hippocratic Medicine, which coincidentally was incorporated in Amarillo, Texas, mere months before this case was filed. So it is such transparent judge shopping to get a nationwide injunction, to not return the issue back to the states and let people in California and New York and Illinois decide what to do, but have a judge in Texas appointed by President Trump decide for all women in this country whether they'll have access to this drug. So, you know, unsurprisingly, Judge Kaczmarek issued an injunction. He stayed, but the decision was breathtakingly anti-scientific. I mean, the FDA is, you know, for all its flaws, is staffed. I've worked with the FDA before, and staffed by a bunch of really smart people who like do this for a living and draw upon, you know, research scientists. So, you know, the fact that Judge Kaczmarek, who's, as far as I can tell, has got as much health training as I do, probably less, you know, decided that he could substitute his own judgment for the FDA. And I think it's not a surprise that the big pharmaceutical companies came in on our side on that one, because the idea that these Yahoo judges can like substitute and like disrupt their whole drug supply chains because they decide they don't like a particular drug is very disturbing for the drug industry, as well as us. I mean, you may know the status of that case. So the Supreme Court stayed Judge Kaczmarek's order on April 17th. It's now, but we're not done with that one. It's just quiet for a bit. It's back to the appellate court level. There's a hearing on May 17th. It's expedited. So I expect the Supreme Court to get another crack at that one this year. And, you know, I don't know. I think maybe on that one, because of the pharmaceutical industry, they won't come out on a crazy side, but you never know with this court. The other way that I think they're completely ignoring this, let's delegate it to the states, is, and some of you may have heard this, but they are starting to pick a fight over what's called the Comstock Act. So, you know, I had to do research on this. So the Comstock Act, which I think the best way to describe it is called a zombie law. So it was passed in 1873 as a means to criminalize, wait for it, obscene, lewd, I can't even pronounce this word, you guys are gonna laugh, lascivious, whatever, right? Immoral or indecent publications or materials that are being sent through the mails. So it was one of those blue laws, right? That was like really there to criminalize, you know, more immoral behavior. And unsurprisingly, like any publications that mention abortion or the means to perform abortions are covered by the Comstock law. Now, you know, the courts almost instantly laughed this law out of the courts every time it got challenged. They, you know, contraception was banned and the court said, no, we're not banning contraception. But through some quirk, nobody had ever challenged the abortion provisions of the act. Now the courts have sort of hinted at that, well, you know, sure you can't, if abortion's illegal, you can't send, you know, abortion materials to those states, but we're not going to ban it anywhere else. And the DOJ recently has said, you know, if you're sending abortion materials to states where it's legal, we're not going to criminally prosecute it. But the antis are now filing lawsuits all over the country, trying to get a conservative judge to bite and say that, no, you sent any abortion materials anywhere in the United States, and that's a criminal act, felony, that you can get prosecuted for. And I know they're going to find someone who's going to bite on that one, and that one's going to go up to the Supreme Court as well. So, you know, there is these, you know, when I talk about them being disingenuous, like, right, there's clearly no idea of like, you know, we'll return to the democratic will of the people on the state level. This is really an all-out war using every tool they have to try to shut down abortion all across this country. And I'm not even going to, just given time, I'm not even going to get into all the other ways they're criminalizing. Going back to your question, Linda, about whether you should support the ACLU's new initiative, I think 100%. I just want to give you a stat. Since 1973, there have been 1,700 instances of women being caught up in the criminal justice system or some other form of state intervention, like taking their kids away when they were pregnant. And it's usually around drugs and alcohol, right? The most prominent one recently is in Alabama. There's a chemical endangerment statute, which was passed because basically, as the parents brought their kids to meth labs, they could be prosecuted in addition to the drug violation also for endangering their children by bringing them to a meth lab. Well, for the last 5 or 10 years, there's this one zealous prosecutor in Alabama who has used this every time a woman who's pregnant gets arrested with marijuana in her glove box. They get imprisoned with an onerous bond. They can't get out. The state comes and takes away their kids, and they'll force the women to give birth. And then take away their kids as soon as the kids are born. So this happened to over 1,000 women in Alabama over 10 years until finally the governor was shamed recently into stopping the practice. So the criminal justice system as a tool has been used 1,700 women since 1973, but I think significantly, there has been 3 times as many incidents of women being caught by these systems in the last 14 years as there were in the first 20 years after Roe. So we've seen a huge spike in the criminalization of pregnancy and women's choices during pregnancy. And I think we're seeing many states trying to pass laws that will explicitly criminalize abortion and people who provide abortion, even at the state level. So yes, Linda, you should absolutely, think about supporting the ACLU's new initiative, because I think there's women and abortion providers all over this country who are going to be subject to criminal prosecution pretty soon. So what can we do? Well, let me quickly share, and I can share this more broadly, right? How to help. So these are the legal services organization. These are the big 4: ACLU, Center for Reproductive Rights, the Loring Project, and Planned Parenthood, right? All of us, I'm involved with most of them, and everybody, all of them have lawsuits going on all over the country. The Abortion Defense Network is a coalition of these organizations, plus some of the big law firms, including my own, where it's a legal hotline where you can call and get help for providers. So this one you don't donate to, but these 4 you do, you can donate or support. In terms of other resources, in terms of like, say, giving directly to like abortion funds who are helping women on the ground, I actually think this is the URJ's Religious Action Center. This link here is a great resource. It's kind of a list of various resources and abortion defense funds you can give to. It's got links to some of the Jewish action around these issues. I think that's an incredibly helpful website, kind of a one-stop shopping. I know we're getting short of time, so I'll just touch quickly on this. But I think also, one of the things people had asked me about were these religious freedom cases that have been filed recently, right? Now, these are cases where, plaintiffs are challenging abortion bans on religious freedom grounds. There's 3 cases that I'm aware of: 2 in Florida, 1 in Missouri. 2 of these are interfaith, one in Florida and 1 in Missouri, but all involve Jewish plaintiffs. And the argument here is that an abortion ban would impair a Jewish woman's religious freedom because she has a sincerely held religious belief that will require her to have abortions in certain circumstances. So I've been asked, like, are we going to win these? All I can tell you is it's very hard to predict right now. The religious freedom jurisprudence is kind of a mess. And many of these cases are also brought under state statutes called RFRA, or the Religious Freedom Restoration Acts. So those were all passed by Christian conservatives, usually as a way to fight back against school issues they didn't like. But so now, Jewish communities, Muslim and progressive Christian communities are trying to use them, but we don't really know how that's going to turn out. I think that's probably, Rabbi Justice sent me a really interesting article on it. And I think if people are interested in that, that's definitely something that, we should have a further conversation about, because I think there's some really important issues baked into those religious freedom cases that we have to consider as a community, including, actually, I'll show you one more. I'll leave you with this, basically.
And Aaron, before you leave, what we can do with the slides is perhaps put it into one of the Shomrei publications for people who want to see these links. So, yeah. But go on.
Yeah, I'll just leave you with this thought, because I think embedded in these religious freedom challenges by the Jewish plaintiffs is this question of Jewish law. And I kind of referenced it last time, that a lot of the traditional halachic interpretations of Jewish law that would ground these challenges are based in ones that really focus on the fetus, right? When does the fetus become ensouled? My favorite ones are ones that treat, the fetus as a pursuer, and women are allowed to, fight back against their pursuers if the pursuer is trying to kill them, which, that's how I kind of feel more about my teenage boys, that they're always trying to kill me. But this is like, this is really, a halakhic interpretation that kind of gives women the right to sort of have abortions. But what's absent in a lot of those traditional halakhic interpretations is this idea of women's autonomy. And I think if you look at Justice Alito's analysis, when he's looking at deeply rooted history and tradition, well, that's what halakha law does to some extent. And the texts it's relying on kind of suffer from the same defects that the laws that Justice Alito relied on, is most of them were drafted and crafted when women weren't part of the conversation. And so, I think there's a deep question to be had around some of these challenges. And look, there's some conservative Jewish legal scholars who have said that liberal Jews don't have a right to bring these cases because we don't observe all of the halakhic rules, and therefore we're cherry picking and not truly religiously observant. That's been a very prominent argument by some of the conservative Jewish scholars. So, I think there's some deep thinking around this issue about if we do want to bring one of these challenges, what are we grounding it in? Is the law truly robust enough to sustain issues like women's autonomy? And this is a source sheet that Rabbi Danya Rutenberg put together. She's a big voice in this area. And I think it raises a really interesting question, and I'll read it, although you can read it, right? There's a temptation right now to say that the restrictions on abortion rights in the United States violate the religious freedom of Jews. And that is true to an extent, and I agree with that personally. But a religious argument based on Jewish law and rabbinic texts only goes so far. A more complete bodily autonomy argument may not be an argument rooted in Jewish law, but it is a Jewish argument, and it's time to make it. And so I think that's a really provocative argument. I don't actually necessarily agree with it, and that's why I said it's a subject for another time. But I actually think there is ways to construct, maybe not in a strictly halakhic sense, but there is ways to construct a more robust argument around women's autonomy from the texts. But I think this is a really important question as we're thinking about Jewish ways to respond to these abortion bans, not only just giving time and resources and money, but as we're thinking through what does it mean to exist in a religious pluralist society? How do we fight for that? How do we articulate our views in this space? And how do we sort of articulate in a ways that maybe we can make it understandable to courts who are sort of trying to figure out whether they should enforce these rights against these very restrictive state bans. So I'll pause, I'll stop there.
Thank you. I guess we've gotten right to the end of our time, but you've left us, Aaron, with a number of topics that we should continue, and maybe we need to do a little series on questions about religious pluralism and what that means in terms of our rights. So thank you so much. Thank you all for coming.
Thank you, Aaron.
The messages are all coming in and saying the same thing I'm saying to you. This has been really special and important for all of us. So thank you for doing this.
Thanks everyone for taking the time.
Thank you. Thanks.
Thank you.
Night all.
Night.
Aaron, thank you so, so much.
Thanks, Shirley, for organizing it.
Anytime.
Yeah.
Maybe
thank
another
you.
one in the near future.
Shirley.
Maybe
Do it
another one
again.
in the near future, Shirley.
Yes, ma'am. Bye.
Bye.
Take care.